Hello everybody and welcome to our webinar on estate administration. My name is Adrian Bailey and I'm one of the principals of Cleary Hall Solicitors. Today presenting our webinar will be Kate Chalker, who's a senior solicitor with the firm working out of our Sydney office, and she's going to cover off on some of the core areas of estate administration for clients. If you haven't used our system before, just a couple of things to run through before we start. Kate starts presenting. You should be able to see a files button on your screen. If you click on that, you'll be able to download the presentation from today. If you forget to do that during the presentation or you get called away, we will be sending an email later on with a feedback survey, which will also contain a download of the slides from today. There's also a chat question there, or a chat box there. If you've got queries during the presentation, not all queries are welcome. If you've got queries during the presentation or at the end of the presentation, fire them into the chat box. I'll be moderating it and asking Kate at an appropriate time. There will be time at the end of the presentation for questions, but as always, if you think of something while we're going through, often it's a good time to ask it then and there while we're dealing with a particular topic. Our presentation today will be recorded and so will be put on YouTube later on. So again, if you get called away or if you have to go do a client matter, you'll be able to access the recording from our website and our YouTube channel in due course. So I'd like to throw over to Kate, who's going to tell us about those core aspects of estate administration.
Thank you, Adrian. And yes, today's webinar will be looking at the process of administering a deceased person's estate. In recent times, we've covered off quite extensively about preparing a client's estate plan, making sure that they have a well-drafted will, whether that's one of our bloodline wills or a different type of will. But we haven't really touched on recently what happens when that person dies and the different steps that you need to take to make sure that their estate is administered correctly in accordance with their will. So we'll be looking at that process and also looking at some of the different issues which executors and beneficiaries could face during that process. So quickly, just in terms of an agenda for today's presentation, firstly, I'll be taking you through the different legal consequences which can arise on death. So firstly, we'll look at the scenario where a person dies without having left behind a valid will. And in that case, we will need to apply the intestacy provisions, which I'll go through in some detail. Alternatively, we'll then look at the situation where the deceased did leave behind a valid will. We'll look at whether the executor will be required to apply for a grant of probate from the Supreme Court and the type of steps that process will involve. From there, we'll look at some related issues, such as where the deceased was a principal of an Intervivos trust or a trust established during their lifetime, and what will happen with the control of that trust moving forward. I'll also touch on some of the different disputes, in particular family provision applications, which may arise in relation to a person's estate. And then finally, we'll also look at some of the different taxing events and tax consequences which can occur on the death of a person. So firstly, let's look at the situation where a person passes away and they haven't prepared and signed a will prior to their death. So in that situation, that person will be deemed to have died intestate. And that simply means that they have passed away without a will. In that situation, obviously they haven't been able to write down who they want to appoint to administer their estate. They haven't written down who they want to benefit from their estate assets. So we have to look to some other legislative provisions to determine who will look after that estate and where the assets will eventually go. So in terms of working out who will administer the estate, there would need to be an application made to the relevant Supreme Court for what is called letters of administration. It's a bit similar to a grant of probate, but it's where we have no will. We have no will in place for the court to consider. And in applying for the letters of administration, what the court is doing is they're looking at who is the deceased person, who is their next of kin, in terms of who have they left behind, is there a spouse, are there children, and who is the most appropriate person to administer their estate. And so once that application process has occurred and the letters of administration have been granted, that person will then need to distribute the estate in accordance with the rules of intestacy. And there are separate rules in each state and territory of Australia based on where the assets are located. So for example, if you've got real property in New South Wales, that property will need to be dealt with under the New South Wales rules of intestacy. And so over the next few slides, I'll take you through how those rules vary from state to state. So firstly, we'll start with New South Wales, where I practice. And so this little matrix sets out where a person's estate will be distributed to if they pass away without a will and they've left assets within New South Wales. So again, we need to look at who's been left behind, who do we have that we could distribute their assets to. So in the top left-hand box, we've got where a person passes away, they've got a spouse, but they have no children. In that circumstance, all of the estate would go to the person's spouse. If we have a spouse and we also have children, then it depends on who those children are with. So if the deceased had a child with their spouse at the date of their death, then all of the estate will pass to that spouse. However, if there were no children with the spouse at the date of death and there were children from a previous relationship, then there will be a split between the spouse and the child or children from the previous relationship. So in that situation, the spouse would be entitled to the personal effects and the first $490,000 of the estate, plus half of what's left over. And then the remaining half of the balance of the estate would go to the child or children from the other relationship. If we then look at where we have children but no spouse, all of the estate would be left to the children in equal shares. However, if we've got no spouse and no children, then it's a bit of a cascading list of the people who could benefit from that estate. So firstly, it would go to the deceased parents if they're still alive. If there are no parents still living, then it would go to the siblings of the deceased, or if they have passed away, then the children of the siblings. We then move to nephews and nieces, and then grandparents, and then aunts and uncles or their children. But finally, if we get to the point where none of those people are still alive, then unfortunately the result is that the deceased person's estate will get paid to the New South Wales state government. So that's where I've got there, the estate will pass to the Crown. If there is no one left over, that's unfortunately where the estate will be going. The position is very similar in Queensland. It's just a little bit different in terms of where there is a spouse and also children. In that circumstance, the spouse would be entitled to the first $150,000 of the estate, as well as any household chattels. And then depending on whether there is one surviving child or two or more, the spouse will either get half of the balance or a third of the balance, with what's left over going to those children. If we then look at Victoria, again, it's really only where there is a spouse and children where the position varies. And in Victoria, it will depend on the value of the estate. So if it is a smaller estate valued at less than $100,000, then the entirety will be paid to the spouse. If it is a larger estate worth more than $100,000, then there'll be an apportionment between the spouse and any surviving children. So the spouse would receive the first $100,000 and a third of the balance, with the remaining 2/3 going to the surviving children. In WA, the position is a bit different, and I understand they had quite a significant revamp of their intestacy provisions early last year. So if we look at WA, where we have a spouse but no children, it's not the same as the other states in that the spouse gets everything. It is divided amongst other family members in Western Australia. So the spouse would be entitled to the first $705,000 plus the chattels plus half of the balance. And then the other half of the balance would be split between the parents of the deceased, any siblings, nephews, and nieces. If there are no parents, siblings, nephews, or nieces, then yes, the entirety of the estate would be left to the spouse. Finally, if we look at where there is a spouse and children, the spouse, it's quite a large amount in WA, the spouse would be entitled to the first $472,000 of the estate, with the balance being divided between the spouse and the children, again, depending on how many children there are. So that was just a bit of a quick snapshot as to how the different intestacy provisions apply in the different states of Australia. And so that is what the person who's granted the letters of administration would need to do with the estate assets. They would need to follow that matrix, look at who's remaining, and distribute the assets accordingly.
Just a couple of questions, Kate, before you move on.
Okay.
Do you only need to apply for letters of administration in the state the deceased resided in, or do you need one in each state assets are held?
Yeah, it would be wherever the assets are held. So it may be the case that you need to apply for letters of administration in multiple jurisdictions to deal with all of the assets.
Yeah, and usually you do that by, you get it in what you'd consider to be the main state,
yeah,
where they lived and where they had assets, and then you get it resealed in the other states.
Yeah, that's right.
And a bit of a brain question for you, Kate. What thoughts on why the differences between the states?
Not really sure on that one. I hadn't given that one too much consideration. Yeah, I'm not really sure why the figures vary. Obviously, it's quite large in WA and it's smaller in Victoria and New South Wales, for example. Yeah, I'm not quite sure why the government's decided to go with those figures. Not sure whether you have any insight, Adrian.
No, I think it's just a function of our confederated nature. So each state does their own thing to a certain degree. Just a question, assets held shares, where would you apply for admin? That's going to be where the share register is. So if it's in Victoria, that's where you would apply for it. Yeah, that's all it for now. Okay.
Right, thank you. So as I mentioned, if we are going through the intestacy process and we're looking at that matrix and there's no family members who have survived the deceased, the estate will end up going to the relevant state or territory government. There is a bit of an exception in the Northern Territory, Tasmania, and New South Wales if it can be shown that the deceased was a member of a particular Indigenous group or community. Then there may be able to be an application to have the estate go in accordance with that group's customs and laws. But in the absence of that, it will be mandatory to follow those rules of intestacy and to follow that matrix that I had on the previous slides. So as we can see, there's quite a few issues when we look at intestacy and dying without a will. The first issue is that it's very unlikely that the ultimate distributions will accord with the deceased's testamentary intentions. Normally, people want their assets to pass to their spouse, their children. Sometimes you want particular assets to go to particular people. You might want some gifts to go to charity. That's simply just not going to happen if we are relying on the rules of intestacy. As I mentioned before, if there are assets in different jurisdictions, you're going to have to apply that particular jurisdiction's rules to the asset. So you could have differing results in different states. and it could be a bit difficult administratively to work out who is getting what. Another thing to keep in mind is that under these provisions, stepchildren are treated the exact same as any biological children of the deceased. So where many people would like their estate to flow down to their biological children, that simply wouldn't occur under these intestacy provisions. Those assets would need to be shared with any stepchildren which may be alive. And finally, any children of the deceased are not able to actually take possession or control of any estate assets until they turn 18. So if they are to be left something under the rules of intestacy, then their guardian would need to look after those assets until they reach that age. So what's the obvious solution? Make sure that we are putting valid wills in place, particularly when people have significant wealth, they've got valuable assets that they want to leave for their future generations. Make sure that people are putting in place a will early while they're healthy, while they have that mental capacity to do so, so we can hopefully avoid the intestacy provisions from applying. Okay, let's move to
Sorry, Kate, just before you move on.
Sure.
Question, if there is a short-term de facto, at what point are they considered a spouse?
Yeah, it's not quite a black and white answer anymore as to when a person becomes a de facto partner or a spouse. There's no minimum period of living together, for example. There's a number of different factors which the court would need to weigh up when considering whether someone is a spouse. And they include things like whether they were living together, whether they had jointly held assets, bank accounts, whether other people in the community saw them like a married couple. There's quite a long list of different factors which would need to be weighed up. So yeah, I'm sorry, Leanne, can't really give you a straight answer on that one. But yeah, a lot of factors that would need to be weighed up in making that call.
Yep, thanks, Kate. That's all for now.
All right, so now we're moving to the second scenario where a person has passed away and they have left a will. First thing we need to consider when looking at that will is it valid? Is it going to hold up? And so in order to check whether a will is valid, we need to look at how it's been executed. So obviously it needs to have been signed by the testator, that is the person making the will. And then it also needs to have been witnessed by 2 individuals over the age of 18. And those witnesses cannot be named beneficiaries under the will. So the other requirement is that the will needs to be dated on the date of execution. And that's particularly important when we move to the probate process, because the court will need to be satisfied that the document in front of them is the last will and testament of the deceased. If there is some uncertainty as to when it was executed, then there could be a question, is there a later will that perhaps would take precedence over this document? I haven't listed it on the screen, but another thing that we need to consider is whether the testator had testamentary capacity at the time of making the will. If, the deceased had dementia or Alzheimer's, or perhaps they were in hospital and on some heavy medication at the time of signing the will, then there is the potential that a beneficiary could challenge the will on the grounds that they did not have the testamentary capacity to make the will at the time. And if that is successful, or if the will hasn't been executed correctly, then we would be moving back to that previous territory where we are applying the rules of intestacy. So need to make sure that we have a will and that it is also validly executed. If we move to that next stage and we're satisfied that there is a will and that it is validly executed, these are some of the things that we'll be looking for next. So we would review the will and see who has the testator appointed as the executor or the executors, plural. there can be up to 4 executors of a will. And so we need to look at who has been named in the will. Are they still alive and able to carry out that responsibility? We then need to look at who are the beneficiaries named in the will. Are there any specific gifts which have been made? Has a particular property been left to a child, or are we simply dealing with the whole of the estate, the balance of the estate, a particular share of the whole of the estate? We'll be looking at what's been listed in those gifting provisions. We'll also be looking to see whether under the will there is a testamentary trust established, and if so, who has the testator appointed as the trustees of that trust, and who also are the eligible beneficiaries of that trust. So these are some of the initial considerations that we'll be looking at when we're notified of the death of a client and we're reviewing their will. So I've mentioned a few different roles when I was going through that list of considerations. So I'll just go through those in a bit more detail. So the first one is the testator, the person who makes and signs the will. Normally, you have to be over the age of 18 to be able to make that will, predominantly for that testamentary capacity reason, and that you need to reach a certain age to be able to understand what you're doing by signing that document. However, there may be certain circumstances where a minor can apply to the court to make a will under the age of 18. The court would just need to be satisfied that they do have that knowledge and that capacity to do so. The next role is the trustee, and I'm not necessarily talking about the trustee of a testamentary trust, for example. You may have seen in wills where it says, I appoint John Smith to be my executor and trustee. Often they are the same person, but by that we just mean that until the estate is fully administered and the assets passed on to the relevant beneficiaries, we need somebody to hold those assets within the estate for the benefit of those beneficiaries.
Okay, just a question.
Sure.
Is it worth getting a cognitive report done to support the health status of the deceased at the time of signing the will?
Yeah, definitely. If you can foresee that there may be a question raised about their capacity or a potential dispute about the validity of the will, it's certainly worthwhile putting some evidence down, whether that's from a doctor or whether it's from the lawyers who are perhaps witnessing the will at the time. It's a good idea to get that evidence so it's there, it's ready to go in the event of a future challenge.
Particularly if they're making changes to previous wills, which often happens. But, yeah, thanks, Kate. That's all for now.
The next role we have under a will is the beneficiaries. These are the individual people or even trusts or companies to whom the estate has been left to, whether that's specific gifts or a portion of the estate. And then finally, we have the guardian, and this is a person who will care for the minor children of the deceased. So if mum and dad, if one of them passes away, then ordinarily the surviving parent will continue to maintain control and care for their children if they're below the age of 18. But it's when both of the parents of the child have passed away that the guardian would need to step in and assume care for them. Sorry, I shouldn't have said finally, because there is one more, and it's probably the most important role within a will, and that is of the executor. And this is the person who is responsible for carrying out the administration of the estate. So firstly, they would be responsible for organising the funeral, looking at the will and seeing, does this person want a cremation? Do they want a burial? Are there any particular wishes that they have in relation to scattering of ashes or anything of that nature? And from there, they would be responsible for calling in all of the assets of the estate, paying any debts of the deceased, and also obtaining a copy of the death certificate, which is a compulsory part of the probate process. And we sometimes get asked whether the executor is able to charge for their time in administering the estate. And the answer is yes, providing that it's allowed for under the will. So particularly where you're having a professional person appointed to the role, an accountant or a solicitor, the will often provide for them being paid for their time. But otherwise, if it's not in the will, then they won't be able to charge for their time and their services. Okay, so obviously there's quite a lot of responsibility on the executor in carrying out that role. There's a lot of meetings, a lot of documents to sign, and also a lot of different personalities to manage. If you've got beneficiaries saying, "Where's my money? Have you administered the estate yet?" So it can be quite an onerous process being an executor of an estate. So sometimes you will have people who have been nominated under a will to be an executor, and when it comes to the time of actually carrying out that role, they say, "Actually, I don't think this is for me. I don't want to be the executor of this estate." And so they're not bound to carry out that role. They do have the ability to renounce their position as executor, and they would be required to file a form with the court if it is going through probate. And if that does occur, then we would look to the will, and if there is a backup executor, then that person would take their place in being the executor. But otherwise, if the executor renouncing their position can't find someone else to take the role, then it would need to go back to court. And much like the intestacy provisions, the court would need to determine who is going to carry out this position.
Sorry, Kate, to cut you off. Just a couple of questions. Where the deceased is the only director of a company with just one issued share, or another company with two ordinary shares, one held with the deceased and one held by the spouse, how do you appoint the spouse as the new director of either company?
Yeah, so it's the legal personal representative or the executor of a person's estate that would be able to appoint a director of the company in their place.
What is the rough cost to the estate should an executor renounce?
That's difficult to say. Actually having the executor renounce their position and notifying the court of that is very straightforward. That's a simple process in itself. But then it's a matter of, is there somebody else who's willing to take on the role, or do we need to take this to court to find somebody else who can carry out those duties? So yeah, I'm not really sure. It would very much depend on the circumstances.
Last one for now. Can you have a temporary executor if the person that you actually want to hold that position is under 18 at the time of death?
I believe you can. I believe you can have it so that one person is executor until the point in time where the person you actually want turns 18. Yeah, I think that is achievable. There would just need to be a bit of a handover from the old executor to the new.
And that's it for now, Kate.
Thank you. Final point on this slide is that you can absolutely appoint a solicitor to act on behalf of the executor to apply for probate and to do the necessary distributions once it has been granted. But it's important to remember that the responsibility and the decisions are still on the executor. Whilst we can help out with the administration process, absolutely, we still can't do that without the instructions of the executor. Okay, so we move to the next point now, which is where the deceased left a will. We've decided that it is valid, and we've worked out who all the relevant people within the different roles are. So the next job for the executor is to work out what assets and liabilities are within the estate. So the executor will need to ascertain whether the deceased owned any real property, motor vehicles, cash at bank, shares, whether that's ASX shares or shares in a private company. They may hold some investment bonds. They may have interests in other businesses. In addition to that, they may have some life insurance policies, whether that's within their super fund or through another provider. They may have an interest in another partnership. They may have assets overseas. And also, if they were living in a nursing home when they passed away, they're also likely to have a nursing home bond or a refundable accommodation deposit. So the executor will need to work out what did the deceased own, and as part of the probate process, they'll need to put an actual or an estimated value on each of those assets so that we can work out what the estate is worth. Important point at the bottom is that we need to determine whether any jointly held assets are held as joint tenants or tenants in common. And the reason for that is any assets held as joint tenants do not actually form part of a person's estate. And that's because under the rules of joint tenancy, on the death of one joint tenant, the asset will automatically pass to the surviving joint tenant. So if we've got mum and dad holding a property, if the dad passes away, then all that would need to happen is that we'd need to notify the titles office that the dad has passed away and that the property needs to be registered in the name of the surviving joint tenant. So those assets would not actually form part of a deceased person's estate. Alternatively, if you've got assets held as tenants in common, then that person's interest in the asset would form part of their estate. So if the property was held by mum and dad as tenants in common in equal share, then the dad would be able to deal with his 50% interest under his will, and it would form part of his estate on his death. So it's a really important distinction that we're looking at the actual method of ownership where we have jointly held assets. On the flip side, we need to work out what debts and liabilities did the deceased have. So there may be mortgages, there may be personal loans, personal credit cards, or even if the deceased was in hospital or in some type of palliative care before their death, they may have some medical and hospital accounts owing. Also, there may be a funeral account, or perhaps if they were really organised, they may have prepaid that before their death. Also need to consider whether the deceased had any litigation on foot. If the deceased was a defendant in a particular case, then some money might need to be set aside from the estate to deal with that potential judgment. And also need to look at whether the deceased had any income tax liabilities. So executor needs to work out what are the assets, what are the liabilities, what are they worth, so that we can calculate the net estate and what's left over once all of these liabilities are accounted for. Okay, once that has been completed, the executor will then need to consider, do I need to apply for a grant of probate? And so probate is a formal process of verifying the validity of the will. Literally translated, it means proving the will. And it's granted by the Supreme Court of the relevant state in which the assets are held. And so once probate is issued, that's the court saying, yes, this document in front of us we believe to be the last will and testament of the deceased person. And it also approves the appointment of the executor. And so once that is issued, the executor can then go out with the authority of the court and administer the estate in accordance with what is contained in that will. So why would executors go through that process? Firstly, they may decide to go through probate because the value of the estate is quite significant. And there's a potential that beneficiaries could ask questions about whether what they're receiving is correct under what's been written under the will. There may be also some concern about whether the will is the most current. If there is another document floating around which someone thinks may be a more recent version of their testamentary intentions, then that would come out as part of the probate process. But if probate is granted, then you can be satisfied that that is the most recent version of the will. And then finally, you may need to apply for probate just based on the nature of the assets within the estate. If there is real property within the estate, then you absolutely have to apply for probate because the titles office will not deal with any real property interests without first seeing that grant of probate. And also in terms of banks and financial institutions, once the balance gets over a certain sum, the banks often will not release any of that money until they receive a copy of the grant of probate.
Okay, before you move on, we've got a few questions banking up, so we'll get into them now. I interpret it the same. So if a loan is secured over property owned as joint tenants, does the loan also transfer to the surviving joint tenant?
Yes.
Where do you go to find out whether an asset is held as joint tenants or tenants in common?
Yeah. Well, it will depend on the type of asset. If it's property, you would do a title search and it would be listed on there. If we're talking about a bank account, you could contact the bank, get a copy of the bank statement, and that would detail how those funds are held. With shares, that information should be listed with ASIC as to the type of ownership. So yeah, depending on what the type of asset is, it should be listed on the register as to how it's held.
What about estates that are small and have no real property in them as property was owned as joint tenants? Do you need probate?
Yeah. Good one, Brad. I was just getting to that point in that, yeah, if it is a small estate and because of what's contained within the estate, there's no need for probate, then the executors may elect not to go down that path and just to proceed with what's written in the will without needing to approach the court.
Is it worth considering transferring title of a solely owned main residence to joint tenants while alive to avoid any potential issues, complications with administering the estate? Yeah,
it's definitely a consideration, and that can be done if you've got property owned by husband and wife. That can easily be changed to joint tenants, or on the reverse, it could be changed to tenants in common. Some people don't like the thought of that because they know that it will automatically pass to the surviving spouse. And what if they go and repartner? There's a potential of that property being lost to the new partner. But yes, you're right. It would make the administration of that property certainly much simpler.
Leave the rest to the end, just in the interest of time, Kate.
Yeah. All right. So just on the point that Brad was making, going and applying for probate can take quite a while. I know certainly in New South Wales at the moment, the court is very delayed and very backlogged in processing probate applications. So it's not unusual to have to wait 3 or 4 months for a response to come back from the court. And then you have to hope that everything is in order and that there's no requisition, in which case you have to go back and wait even longer to receive the grant of probate. And also the filing fee is based on the gross value of the estate. So if you've got a large estate, the filing fee in New South Wales could be over $5,000. And that's disregarding any costs of having that application prepared. So it can be a protracted and expensive exercise. And if you've only got assets held as joint tenants, or if you've just got a small bank account balance and you just don't need probate, then you don't necessarily have to go through that process. All right, this is just a point on where we have an Intervivos trust, being a trust established during a person's lifetime. If the deceased was the principal, the appointer, or the guardian of that trust, being the person who can remove and replace the trustee, we need to consider who will take on that role after their death. Because even if a person is the sole trustee or the sole director of a corporate trustee of a trust, even if they're the sole principal and they are a beneficiary, so it's completely directed by them, the trust is not going to die with that person. It will continue, depending on the terms of the trust, it will continue for up to 80 years. And so we need to look at who will assume control of that entity. And so we would normally recommend that they execute a deed during their lifetime, appointing a successor principal, appointing someone to take over that role upon their death. But this can also be achieved in a person's will. They might include a clause in their will which says, I appoint my son to take over as the trustee or the principal of this existing trust. So that's also another thing that we need to be looking at when we're reviewing a will, to see if it deals with any existing trusts. Okay, so another complication in the estate administration process is the potential for there to be a dispute or a family provision claim. So there is legislation within each state which allows a person to make a family provision claim against a person's estate. And that would be where an eligible person, I'll come back to that term, makes an application to the court to say that adequate provision for their proper maintenance and support has not been given to them from the deceased estate. So it's where a person is saying either I've been left out of a will, or perhaps we're looking at a $10 million estate and they've only been left $100,000. They'll be saying I haven't been adequately provided for under the will, and they'll be asking the court to effectively rewrite the will to make an adjustment in their favour. There are some time limits in relation to making such a claim, and it will depend on the jurisdiction. But in New South Wales, that application would need to be lodged within 12 months of the date of death. In Queensland, it's a bit more expedited in that you have to give notice of your intention to claim within 6 months and then actually lodge the application within 9. If you miss that deadline, there is the option to seek special leave from the court to file the application late, but you would need to have a pretty good reason as to why it wasn't lodged within time. I said that you need to be an eligible person to make a family provision claim. And again, this will depend on the relevant jurisdiction, but this normally means a spouse, including a de facto partner of the deceased, or even an ex-spouse or ex-de facto partner. You'll also be an eligible person if you are a child of the deceased, including a stepchild. And also if you can prove that you had a dependent or an interdependent relationship with the deceased before their death. That one's obviously a little bit more difficult to establish, but if you can show that you fall into any of those classes, you'll be able to lodge a family provision claim to try and have an adjustment made in your favour out of the estate. And so how does this affect the administration of an estate if you find out that there is going to be a family provision claim? It can obviously be quite disruptive to the process and can cause quite a few headaches along the way, because firstly, there can be no distribution of the estate assets while that application is before the court. And it's not unusual to see these applications go on for 18 months, 2 years. So the whole estate administration process is put on hold while that application is being determined. There's also the fact that if the executor goes ahead and distributes the estate assets before that claim is made or before it's determined, then they could be personally liable to make up the shortfall if there is an adjustment in their favour. So it's normally pretty prudent to make sure that there's not going to be a claim, or to make sure that the time limit has passed before going and distributing those assets. Another drawback is that often the costs of making that claim will come out of the estate. So people will often say that the only winner in a family provision claim is the lawyers, because each of the different parties have to have their own separate legal representation. And as I said, it's a long, protracted process. And the lawyers know that their costs are going to be paid out of the estate if there's money there. So that's why, if possible, we would always recommend that if there is going to be a claim, that you try and settle it outside of court. You come to an agreement between the beneficiaries and the person making the claim to avoid the process from ending up in a final hearing. Another consideration, it doesn't include joint or trust assets, so it won't hold up, for example, moving a jointly held property into the surviving joint tenant's name. But also need to be aware of the notional estate in New South Wales, which is a special rule that we have here, which says that if you go and you give assets away within 3 years of your death, then if there is a family provision claim, those assets could be clawed back into the estate and could be used to make an adjustment. Okay, so now I'm going to look at some tax considerations which are relevant to the death of an individual. So firstly, if we're looking at CGT, often in a person's estate, there will be a CGT asset, whether that's real property, shares, motor vehicles, whatever it might be. So there are particular provisions under the Tax Act which prevent there from being any CGT liability when the assets are moved from either the deceased to the executor or the deceased to the beneficiary. But we do need to look at what happens to the cost base of that asset when it reaches the hands of the beneficiary. If the asset was a pre-CGT asset in the hands of the deceased, then it won't maintain that pre-CGT status, but it will get a cost base upgrade, in that the cost base for the beneficiary will be the market value of that asset at the date of death. If we're looking at post-CGT assets, you will keep the exact same cost base as what the deceased had before their death. So it will be the same cost base as the deceased. If we are selling a CGT asset, if the person was alive, we would look at potentially applying the small business concessions. And there may be an opportunity to also apply those after death. However, the asset needs to be disposed of within 2 years of death. And if we were selling the asset during the lifetime of the person, they would have needed to meet the requirements of the concession. With the 2-year time period, there is the option for the commissioner to extend that period to allow them more time to access those concessions. But again, that's on a discretionary basis, and there would need to be a pretty good reason as to why it wasn't sold within that 2-year period. Now, if we look at main residences and dwellings, again, if we were selling the main residence of an individual during their lifetime, used as their main residence, not used to produce any income, if that property were to be sold, there would be no CGT consequences, because we would just be able to apply the main residence exemption and there would be no resulting CGT liability. Much like the small business concessions, we can carry over that exemption after death. But again, we need to look to that 2-year time limit. So the property has to be sold within 2 years of the death of the deceased. And this is where we're looking at a post-CGT property. If we're talking about a pre-CGT property, then again, there will be no CGT liability on the sale of that asset, provided that when it is sold, it is being used as the main residence of either the spouse of the deceased, an individual who was granted a life tenancy under the will, or another beneficiary of the estate. So as you can see, that there's a few different tax considerations which can come into play, but if proper tax advice is sought, then some of the assets should be able to be sold, applying those concessions or exemptions to achieve a better tax outcome for the estate. So that's all of the content that I had. I suppose to sum up, estate administration can be a little bit tricky, and we're also mindful of the fact that it's often at a very difficult time in people's lives. So if we're getting involved, our job is just to make that process as simple as possible. And it's also important that a person has a valid will during their lifetime to make that process simpler and to avoid having to apply the intestacy provisions. But yes, if the estate plan is looked at early, then that should make the estate administration process a whole lot easier when that time does come around. So I'll probably hand over to Adrian if we have any further questions.
Questions? We've got plenty of questions, Kate. So I'll just I'll give you a minute to have a drink of water or whatever you want to do. Just to remind everybody that the feedback email will come out at the conclusion of the presentation. Only a couple of questions. If you could take the time to complete it, it's much appreciated. As I mentioned, the slides will also be attached to that feedback email. But one of the things that we ask is potential topics, and today's presentation was a request from a few people at one of our previous sessions. So a couple of questions here for you, Kate. The executor is the sole director of the company, which has assets in its own right. And the company also acts as trustee of a deceased person's self-managed superannuation fund with a nomination to pay adult non-dependent. Can the executor cease as director and transfer shares in the trustee company to the same beneficiary?
Yes, I believe they could. If the executor is stepping into the shoes of the deceased, then they would be able to appoint a new trustee or appoint a new director and to be able to deal with those assets. Yeah.
I think you, in terms of, obviously you need to work through super fund rules in terms of directors and shareholders of super funds and who has to be in that situation. And again, it's going to depend on whether there's other members and those sorts of things. How do you deal with the bank if you do not get or need to get probate?
Yeah. Well, then you would just contact the bank, notify them of the death of one of their customers, and then they'll often ask for the death certificate and a copy of the will if it is available, and then they'll be able to provide the executor with a copy of the bank statement to show what's in those accounts, and if it's only a small bank account, they should just be able to deal with that internally without needing to apply for probate. But yeah, it's just a matter of contacting their deceased estates team and getting that process started.
Grant of probate required in intestacy?
No probate in intestacy. Probate is only where you have a will. The process where there's no will is that you need to apply for letters of administration, which effectively gives the person the same rights as if they had probate to go and administer that estate.
What if the loan is in joint names, but the property is in the deceased name only?
Yeah. Well, then the loan would become an obligation of the surviving joint tenant. So, yeah.
Surviving co-borrower, not joint tenant.
Okay.
The property is just in the deceased name. Yeah, I mean, in reality, what would happen is that the survivor would still be liable for the loan, even though they may not hold the property if it goes elsewhere under the will. If your only next of kin was two siblings, which sibling would rank higher?
They would rank equally. If we're looking at intestacy, you look at the whole, the class of next of kin, and so you would look at whether the deceased has any siblings. If there's one sibling and that's who's entitled to the estate, they would get everything. If there's 5 siblings, then it would just be split between all of them equally. So they would all rank the same.
If property is willed to an individual, can the individual elect to transfer ownership to another entity without incurring additional costs?
Yeah, not normally, because the tax concessions that apply for deceased estates apply where you are doing that in accordance with the will. So if you are changing that and you're saying, I want this property to go somewhere else, then it's very likely that there could be either CGT or stamp duty consequences on that transfer.
Just a comment from Shane about the earlier question and answer about potentially changing to joint tenants to avoid estate administration, so to speak. Makes the point there may cost stamp duty. That's true. There are exemptions for spouses and main residents, but obviously that's part of the consideration in terms of overall cost. For a family provision claim, does this need to be applied for in each state that the deceased held assets, or just the state of residence?
I'm not actually too sure on that one, Adrian.
Yeah, so you would have to apply in each state because the rules are slightly different in each state. And there was a recent, well, not so recent now, time gets away from me these days, but a recent case involving one of the Pratt estates where the mistress had to apply in different states because the assets were held in different states. Continuing on that vein, or family provision claims anyway, can an eligible person make application for adequate provision when the deceased has no will? The answer is yes. Even if you're intestate, you can make an application for family provision. You have to work through the same considerations in doing so in terms of whether you're eligible, whether you're being dealt with adequately. What happens to assets, for example, shares, if the executor and or beneficiaries are non-residents?
Yeah, it gets a bit tricky when we've got non-resident individuals receiving assets. That could obviously be a tax issue if we've got assets going to foreign residents. If the executor is living overseas, then it would be difficult for them to administer the estate. So it would probably be a good thing in their situation if they could renounce the position and have someone who is an Australian resident and who's nearby to take up that role instead of them.
Yeah, it's I guess the tax considerations for the beneficiary is it taxable real property? Is there a CGT rollover, or is there a CGT event? So it's going to depend on the circumstances. Can you please elaborate on the notional estate? Do you recommend this is noted in the will or in a will?
Yeah, we don't normally have it noted in a will because most people, when they're making these gifts, they do so thinking that they're going to last longer than 3 years. But I suppose if it was looking like they were close to passing away, then I suppose, yeah, it could be noted in the will what you would want to happen, but that really only takes effect if there is a family provision claim. So I'm not really sure that would hold up if there was that challenge.
Yeah, just in the interest of time, recognise we're due to finish in a minute. We've got 2 more questions. If you've got other questions, shoot them through and we'll respond to you separately. Second last question, Kate, are there any rules about whether assets need to be sold by the estate or can pass in specie to beneficiaries?
Sometimes within a person's will, they will specify that they want an asset to be sold. But if there is no specification in the will, then the executor and the beneficiaries can really just decide between themselves whether they want the assets in specie or whether they would rather have the assets sold and just receive the sale proceeds. So normally you would have the option unless it's specified within the will.
Yeah. And the last one, which I'll answer because I've read through it, if the deceased had a large tax debt before he dies but has no assets in the estate, who is liable for the tax? Technically, it's the executor who continues to be liable for the debts of the estate. In that circumstance, what you would do would be, in effect, you put the estate into bankruptcy. And you certainly see the tax office doing that in an aggressive way, where clients have passed away with a large tax debt and the tax office is trying to recover some of that debt. They'll actually appoint a trustee in bankruptcy and look to try and realise some assets from there. Thanks, Kate, for the presentation. There was a fair bit to cover there, and I think you did a great job in doing it. We'll be holding, of course, another webinar towards the end of this month. And as I said in the feedback email, if you could send through send through suggested topics, it would be greatly appreciated. Thanks for everybody for tuning in, and we hope that you enjoy the rest of your day.
Thank you.